On behalf of the New York Technology Council, I want to welcome you all to this event, E-Commerce Law Update, Recent Legal Developments That Could Be Game Changers. I am Paul Ellis. I run the legal track for NYTEC. Before we jump into the content, I want to say a few words about the New York Technology Council for those who are not familiar with the organization. NYTEC is a nonprofit organization. We are dedicated to promoting and supporting the technology industry in New York City. We do that through various types of events and activities, education events like this one, networking events, community building activities, and advocacy efforts both here in Albany and in Washington, D.C. We have more than 30 events per year, including our CEO roundtables. We are a membership organization. We depend on members and sponsors to support our activities, to enable us to put on events like this. So we really encourage everyone here, if you're not a member or your organization is not a sponsor, we urge you to become a part of us and to help support what we do. I want to quickly recognize all of our sponsors. We have a large and ever-growing list of organizations that are supportive of what we're doing. I'm not going to read through them, but they're here on the slide. We also have a number of partners with whom we collaborate on various types of events. So again, we thank our sponsors and our partners for their participation and support of what we're doing. In particular, special thanks this evening to New York Law School that's providing this outstanding space. I know for those lawyers in the audience, it brought back all sorts of memories to walk back into a law school classroom, and I'm sure they were all good memories too. Anyway, but this is great space, and New York Law School is a recent addition to the NYTEC family as a sponsor. We appreciate their support and their making this space available. So a little bit about the legal track. We have many types of events for NYTEC. The legal track is just one series. We have events of interest to early stage companies like formation, financing, intellectual property protection. And then we have events which are of general interest, such as this one on e-commerce law. We've had events on preparing a company for an acquisition, on changes to patent law. So there are all types of events which are intended to appeal to founders, principals, executives of technology companies. If you'd like to be on the mailing list, you can give me a business card afterwards, and I'll make sure you get on our list, or to Alice, who's at the door. My name again is Paul Ellis. I run this track. I'm the organizer of the legal track. When I'm not doing these NYTEC events, I'm the principal of the Paul Ellis Law Group. We are a boutique 6-lawyer firm. Does a lot of work with small to mid-sized technology companies, as well as entrepreneurs and investors in areas including company formation, financing, intellectual property protection, operations, and mergers and acquisitions. So with respect to tonight's event, being a lawyer, I have to make my customary disclaimer. This is an educational and informational event. It's not intended to present legal advice, so neither the panelists, nor myself, nor New York Technology Council is here to provide you with legal advice. If you need such advice, you are urged to go consult with your lawyer. It wouldn't have been a legal event if it didn't have a disclaimer, right? For upcoming events, both legal and otherwise, make sure you leave us your business card. To talk a little bit about this evening's presentation, those of you who are familiar with this area know that the area of e-commerce law is changing rapidly. When this event was proposed by Marc, Holland, and I, it seemed like timely and very informative event. I'm really looking forward to what we're going to hear this evening. The handouts will be available afterwards electronically. Again, if you leave your business card, we will make sure to send you a copy of the PowerPoint. Marc tells me that this is going to be an interactive presentation, so you're urged to participate during the event and ask questions, and there may be some Q&A at the end as well. We have an outstanding panel for this evening's event. We have Marc Reisler, a partner with Holland & Knight. We have Aaron Goldberg, an associate with Holland & Knight, and Tanya Bridges, senior counsel with the company Mindspark. So they've put together a great PowerPoint, a lot of great content, and with that, I will leave it to them to each tell us a little bit about yourselves and take it away.
Thanks, Paul. Can everybody hear me? Good. As Paul said, my name is Marc Reisler. I'm with the law firm Holland & Knight. I work in the technology and emerging companies area for Holland & Knight, and we're very happy to give this presentation. Basically, we are broad in our conception of what constitutes e-commerce, largely just about anything relating to doing business over the internet. We saw a number of cases that we thought were very, very interesting, most of which deal with parties that are engaged in actual e-commerce, some of which are dealing with parties that people might think of as not specifically e-commerce, maybe issues relating to software development, all relating to tech, but even the cases that don't deal specifically with e-commerce parties have implications for e-commerce and doing business in one way or another over the internet. If you could just help us by giving me an indication of your own backgrounds, how many in this group are attorneys? Okay, that's good. How many work for large companies? Okay. How many work for startups? How many in private practice? Smaller firms? Larger firms. Okay, so so first of all, it sounds like a lot of lawyers, which I think will be helpful tonight, and it will help gauge how we're going to run this evening. I think that this evening will go a lot better, and I think that we'll have a lot more fun, and it'll be a lot more interesting if I could enlist all of you in the audience to help participate and to give us your views about some of the cases that we're going to talk about. We're going to really tell the stories behind these cases, talk about the actual parties that are involved, some of the motivating factors, and we'd really be interested in knowing from you, based on all of your experience, what you think about some of these cases, what you think about some of these decisions, what the applications could be in your own particular areas of business, what, to the extent that you're advising clients, how that could impact the advice that you would give clients on a practical level. So I hope you don't mind if we ask you generally some questions about how you think some of these cases were decided, should be decided. What, if you were judge, what would you say? We're going to start with Tanya Bridges, who, as Paul said, is counsel at the company Mindspark. Tanya, I might ask you if you could just tell the audience a little bit about Mindspark and perhaps also your background for Mindspark. So let's take it away.
Okay. Hello. Okay, I know I speak soft, so I just want to make sure that everyone can hear me. Good? All right. So yes, I am a senior counsel for Mindspark Interactive. It is an IAC company. And prior to joining Mindspark, I was a senior counsel for ESPN in their digital department, handling all their digital matters, web, mobile, as well as all their music matters. Prior to that, I was at Jdate Entertainment, which was a Sony Music and an Italian company called Jdate SBA startup company, which was an online and mobile music store. And enough about me. Let's get into the cases. So, Lisa Zaltz, I think I'm saying it right, versus Jdate. And the background here is that the plaintiff signed up for the service. And when she signed up for the service, she, I guess, apparently signed up for the free version and didn't realize that she was getting billed monthly for the service. The case is that she was improperly billed for several months. She then contacted the company and told them that she was complained and nothing was done. And once she put in the complaint, she alleged that she was receiving prank calls and sexual prank calls from the website company. She brought suit in New York Supreme Court, Nassau County, and the defendant motioned to have it dismissed or transferred to California based on the form selection clause contained within the TOS, the Terms of Service, on the website. So, the Terms of Service stated that it had a dispute resolution in which the choice of law was going to be in the state of California. So, the court looked at this and came up with a three-prong test as to whether this would be presumably enforceable, of whether or not this would actually, based on the dispute resolution, which is listed, of whether that would be enforceable or if she would be able to keep her case in New York. And the three-prong test was basically, one, was the clause reasonably communicated to the party challenging the enforcement? Two, was the clause mandatory rather than permissive in nature? And three, was the claims involved are subject to the clause at hand? If the three-prong test was met, then it would then shift to the plaintiff. And the plaintiff would then have to overcome, Then the burden will shift to the plaintiff. The plaintiff would have to prove one of the following. The incorporation of the clause into the agreement was a result of fraud or overreaching. It deprived her of her day in court due to grave inconvenience and unfairness of select forum. Three, the fundamental unfairness of the chosen law may deprive the plaintiff of a remedy. Or last, the clause contravenes a strong public policy in the forum states. The court applied the three-prong test, first starting off with, was the clause reasonably communicated to the party challenging the enforcement? The plaintiff's defense, which I love the most, is, I don't recall the TOS to have been the same that I signed up for. And I don't believe these are the same terms of service I signed up for. And then lastly was, I don't believe that I agreed to the terms of service stating that I have to sue in California. Based on that, what do you guys think the court ruled? Yep. Oh, yeah. Guess I gave it away early. Well, the court said, surprisingly, the court did not find her defense to negate an overwhelming evidence demonstrating the plaintiff had that she had first agreed to the terms and service used on the website. And what the defendants did, which is very smart, and the reason why I want to discuss this case is that your terms and service are very important on your website. They do give you defenses to claims of this nature that arise up. And the defense was very good at making sure that this was communicated to her because, one, on the website, before you can even proceed further into registration, you had to check a box that says that I confirm that I have read and agreed to the terms and service. And then, second step, accept and continue. Hit the button. And the court found that this was enough to say that she was reasonably communicating the terms and service. And further, that once you click the box next to it was a hyperlink, and the hyperlink showed showing the plaintiff precisely where to access the terms of service, and before she agreed to them, and it was up to the plaintiff to determine to click on them and to read them before she agreed. Because of that, the court found in favor of Jdate.
Tanya, I wonder how many people here work for companies that actually have that do business on the internet, that have websites that have terms of use. Can we show anybody at all? I mean, this is still a significant issue. We've been dealing with this issue probably for at least 15 years. What constitutes terms of use relating to a website that are enforceable? And it's becoming an issue. It continues to be an issue because some sites we register for, some sites we don't register for. If we register for a site, what's the process by which people are informed about what the terms of use are for that site? Which, it's a contract, right? It's a contract that deals with the terms that are going to apply for use of the website. And some sites you register, some sites you don't. And what is going to be, if you have a site that you register for, and there's a process that's very, very clearly put in front of a person that you have to accept these terms, and if you don't, then you can't use the service. Well, that's easy. But then there are other websites where you don't register for, and what about the terms of use for those websites? Are they enforceable? It's an issue in e-commerce that we're still addressing. Yes.
Well, yeah, even in the sites where they have to say "click I agree," you're expected to read a several thousand long word agreement in a little box. So now what some sites are doing is saying, "Click here to have the terms of service emailed."
Right.
Which I think is brilliant. And because those things are so long, I tend to read them because I'm just kind of curious about it, because I've seen a lot of them and I'm just interested. But that's a nice idea, so that someone can't say, well, it was unreasonable to expect me to read thousands of pages of words long terms of service through a little box that's 2 inches high.
So that's interesting. So sending an email, so let's say you send it an email, but it's still 1,000 words or more of stuff.
Yeah.
I mean, do you think that somebody who signs up for a service like that ought to have to live by the terms that are in that, that's in that contract?
Can I just ask you to clarify what that distinction, that legal distinction that you were saying, registering for a site versus? So
there are websites, there are services, Facebook is one well-known example, where in order to use the service, you actually have to register online, provide certain information about yourself, and during that process, there will be some sort of prompt that will say, in order to use this service, and it'll be right in your face, right? It'll say, in order to use this service, you have to agree to the terms of use. And like the gentleman up here was saying, there have been a string of cases that have said that the best way to conduct that process is to put those actual terms, that actual contract, right in your face. And there's usually some sort of a window that will open up that will put that set of, that contract in front of you. And then beyond that, there will be a little button that will say, I agree to the terms of use, or maybe another one that will say, I don't agree to the terms of use. If you click on the one that says, I don't agree to the terms of use, then you'll get a prompt that will say, well, you can't use the service. So that's all a system of getting someone to become aware of the terms.
I understand that, but what's the other case? Like
so then the other example is you don't have any kind of process like that, but at the bottom of a website, we have something that says terms of use. And and there may be nothing more than a link at the bottom of the website that says terms of use. And if you never click on that link, you may not ever know what those terms are. You may not ever know what the terms of that contract are, of that contract are.
I don't know.
And yet, they may be applicable to you. And they'll usually start off with saying something like, if you continue to use this service, then you are bound by these terms. It's a very different process, right? One's put in your face, the other is not.
Right.
There is, and we'll discuss some of that tonight, there's a legal regime to address the first process, which is discussed in this Jdate case. But there's also a legal regime to address the enforceability of the second one as well. And if you follow it, then it will be, for the most part, enforceable. They're called browser agreements.
Just to follow on, so to speak of the content of these agreements, these terms of use, terms of conditions, companies typically give short shrift to what's actually in that 1,000-word document. And it's critical when you're counseling clients or if you're in-house to understand actually read and go through it on a regular basis. When I was a junior associate, I was tasked with applying these terms and conditions, go find some. So I went on the internet, I found 10 really big companies. I said, well, let's put their counsel together. In 6 of the 10, I found the same typo. Right? It was maybe one out of them, they actually referenced the wrong company link. At line 999. And at that point, I realized I was the only one that ever read these things. But, these things are important. I mean, we all see them, and they just go right by us. That's something we'll also discuss. Screens at the bottom, but counseling clients, it's important to remember, this is a contract, and this is our face to the world. So,
and Tanya's case?
Just to piggyback off that, while I was at Data Entertainment, a lot of times we would have to do cease and desist because people would actually come to our website, copy terms and condition, privacy policy, put it on their website, still have our contact information, our company name into it, and then somebody would complain saying, I was on your website, and this is the domain name, and this is the terms and conditions, and we're like, that's not our company, and I'd have to contact them, and it was like, if you're going to take them, at least change the information that's in it. And so, like you're saying, a lot of companies don't realize that this is a bound agreement between you and your users, and it needs to be taken very seriously because you will find yourselves in class action lawsuits, and unfortunately the world is filled with a lot of crazy people who will find any reason to contact you about some small and minute thing about your website or your mobile application, and this is what's going to protect you.
And then finally, you can have all of these processes in place. And remember, this is a significant issue for the parties in this Jdate case because it meant that if they were going to try and get some sort of recourse against Jdate, they would have to go to California. So it has a real world impact. And then finally, even though you go through this entire process to make somebody aware of what the contract says, how do you change it? What if you want to make changes? One of the things in this case is that the plaintiff said that I don't recall signing these terms of use, and that may be true. That may be that when they first got to the website, they saw a certain contract, and then it was changed subsequently. So now you have to think about whether the enforceability of what the enforceability of the change is.
But there's always that reason why you put that key clause in there. We have the right to make changes at any term for any reason without notice.
And if you still use the site.
Correct. And another thing that was important within this case was how it was communicated to her. And like we were saying, that this one was very blunt and in your face. It was you had to check the box. There was a hyperlink right there. But a lot of the court was evaluating was that reasonable? Because there were other cases where there was a checkbox, but then you have to scroll down to even see the hyperlink. And it said how many people or how many consumers would actually scroll down the page to click the link. And further, it was if the consumer would reasonably believe or know that that link would lead them to the correct terms and conditions that they needed. So the court found that, not only does it have to be there, but it has to be reasonable that a consumer would actually see it and click on it or have the opportunity to click on it. Okay, so Jdate, let's move on to the next case. The next case is Chapman versus Skype. And with this case, I think the valuable thing that I walked away with it is mean what you print And a lot of people think they can just print something very vague or ambiguous and think that, oh, it's good enough, no one's going to challenge me on it. Or sometimes they play just a game to see how far they can get away with certain things. And in this case, Skype had included an asterisk within the title of their unlimited U.S. and Canada services, which was a disclosure that said a fair usage policy applies. And to the consumer, Melissa, who headed the class action, believed that fair use meant unlimited use because that's what it was entitled, unlimited U.S. and Canada use. The plaintiff purchased the plan and then was found quickly that it wasn't unlimited. She argued that the users required to sign Skype argued that the users are required to sign a terms and condition policy, which stipulates that they were subject to fair use policy and that the fair use policy was not unlimited. Based on that, just those quick facts, do you think that Skype was able to write off those based also on the first case, that just putting in the terms of the service that the policy of fair use was enough to protect them? Hands, yes? No? Okay.
How many of you ever looked on a social net, some sort of social site, like a Facebook, and looked at, they may have something called rules of the road, they may have something, a policy of etiquette, they may have all kinds of things that dictate what your, how you should conduct your conversations online. And sometimes they're called fair use policies as well. And don't you think it's possible that if someone saw something that said fair use policy may apply, whether somebody might think that what they're getting at, because this is Skype, is really more a policy of how you're supposed to use Skype. Whether there's usually things like we can't use this to conduct criminal activity, there's bullying. There can be all kinds of things related to these services. And how many people might think that that's what they're talking about, as opposed to simply saying that when we said unlimited, we didn't really mean it? I'm sorry.
Well, I'll go on with the court. The court found they did a reasonable, was it reasonably communicated again to the user? And they found that the asterisk in the plan, which linked to the statements about fair use statements, contradicted the unlimited nature of the plan. And a reasonable interpretation of the words fair use policy is that they suggested a policy to protect against the misuse of service and not the unlimited plan is actually limited. So the court found here for the plaintiff, again, what we're looking at, was it reasonably communicated to the consumer? And the court found no. Anything else? This was a short, sweet couple.
Yeah, sorry, go ahead.
In that case, was it a similar situation where you would have to affirmatively accept the terms which indicated that you had limited minutes, or was it less than clear on that?
I don't think there was anything specifically. There is a Skype is a registration service.
It's a registration service. You went through saying that you went through the registration, but they had the asterisk, and the asterisk was the issue. It didn't come out clear. It said unlimited service, and then small asterisk, small writing saying fair use policy applies. But then there wasn't really any link to the fair use. You'd have to first go to the terms and conditions, then go to the fair use policy, and then you would see there. So it wasn't actually communicated or reasonably communicated to the user when they were using it.
But I think it was subject to terms of service.
Right. I guess with these cases, maybe they're a little bit old now, or maybe they're not, but I guess one of the things I'm thinking about is nobody reads those contracts. So why doesn't everybody just put it, why don't these companies just put it so that you have to, like, they just pop up a contract and everybody can just not read it?
You'll see
Like,
that.
it just seems bizarre. Like, why wouldn't they just do, like, the most obvious thing and just, here's the 500-page contract. You ready to read it? Okay, good. Accept.
You'll see iterations of that thing throughout these cases, and as a practical matter, the more pop-ups that it takes to get to a website, the less appealing that website is. But you'll see iterations of that theme throughout as we go through.
Can I ask, are you in-house counsel or?
No.
Okay.
I work with some startups sometimes,
Startups.
but I'm not an in-house stuff.
Okay, so I think when you start working with the startups, the first thing I did was working with the startup is I had to learn the same thing. So I'm coming from a law firm, like, just put the terms and conditions out there, let people see them, clear and cut. But then you have your business people who are at the same time saying, you're going to cut down our terms, and people are going to start not going to want to come to our website because they're going to see so many pop-ups. And even worse, that when people do see the terms and conditions, they may be just frightened about so many words or anything that you say that you're collecting data. What does that mean? And then automatically not want to use your service, not download your application, not be part of anything that you have to offer, and walk away. So it's kind of a balance that you have to get. You have to be able to let the public know that you're going to, this is how we're using, our service, this is how it's used, these are the terms and conditions, these are the privacy policies. But at the same time, you don't want to frighten them away to where they don't even want to use your product, because now your business just wasted all that money on that product, and now you can't.
But are you saying if no one reads it anyway, can't we just put whatever we want and make them as favorable to the company as possible, or are you saying something?
No,
Because
that's not what I'm saying. No, that's not what I'm saying. But I guess just like on a not like advising the client level, on more of like a meta level.
Mm-hmm.
I mean, these distinctions seem ridiculous. Like, who cares if it's pops up, or I feel like I feel like there's just a small chance of somebody reading it, whether it doesn't pop up or it pops up. Nobody reads those things.
That's a good point.
Do you read those things? Really?
I originally did, but
How many do you have to look at per
I
day?
wrote it, but
Like, how many per day do you have to look at?
No,
right?
no, you're
like,
absolutely
I don't have 4 or 5 hours a day to read online terms of service agreements.
you're absolutely right. So what?
That's
absolutely right.
I think that there needs to be.
So what do you do?
I think that the solution is really obvious. The law needs to change to make those things less enforceable. Because they're not real agreements, or it needs to change to either just kind of accept that they're completely one-sided agreements, and that we're still willing to enforce that. They're not agreements.
So, yeah.
I think the state of the law is, it's the same here. At least it's analogous with paper contracts on the back of a parking ticket.
But it's not, though. It's really not. That, in reality.
Actually, it is, because in the previous case, they did cite to where whether or not, again, with the reasonable test of whether it was reasonably communicated with them, they quoted a case in here to where a parking ticket or it was a concert ticket that had the terms and conditions, and it just referenced them. It didn't have all of it, just referenced it, and that was
I'm saying that in reality,
valid.
it's not like a parking ticket. Not in the law. Legally, yeah, sure, the court might have, compared it to that, but it's not whenever people get a parking ticket, they read it because it's kind of scary. It's like, I have to look at this now. People don't read this stuff.
I would say that theme will be discussed throughout.
Okay.
Someone in the back.
Yeah.
Yes.
I've encountered the same types of arguments that the speaker was talking about a minute ago. That it's always a battle between the people who are looking for eyeballs and the people who are looking to protect the website. So, in past experience, sometimes we found that the degree to which the terms of service are put in someone's face is sort of measured against what they're doing on the website. If it's just a passive informational website or a blog, then maybe you won't go too crazy. If you have a website that accepts user-generated content, or where someone registers for premium services or something where they're paying for something, then it becomes more important. And then I think in that context, people are more apt to both expect and be willing to click on something because they know that they're signing up for something that's more than just passively reading a website. So I think it may depend in part on the nature of the website itself and the nature of the user interaction with it, and what each side has a right to expect.
Do you think that these websites, you're suggesting maybe that why don't we just accept that they're sort of enforceable term, because
maybe not no. I mean, I don't know. Maybe it needs to just move sort of to a status regime, instead of a legal regime instead of a contract regime. Mm-hmm. I mean, I just think that it's. I mean, I don't want to just keep saying the same thing over and over again, but I just think that it's objectively absurd the way that the law treats these things. It's not like a parking ticket. It's not like signing a lease, because in all those situations, those things happen once in a while, and they cost a lot of money right away. So people are, they get that, I gotta read this. What does this mean?
Well, I mean, if you ever bought stock, right? There's a prospectus that goes along with this. SEC filings that go along with that, detailed financials and risk factors and all that stuff.
Well, if people don't read that, I think that it's just their own problem.
But they don't, right?
Yeah.
So it just comes into the balance.
Yeah, if you open a brokerage account, they give you a lengthy document to read. If you open it online, you probably get the document in a electronic form. Otherwise, you get it in paper form. If you go to a doctor's office, they'll hand you, most places, they'll hand you several papers that you have to sign where you're agreeing that they can
share your information.
Yeah, share the information and that they can collect information and they can send your information to the insurance carrier. It's a whole array of things that they ask you to sign. Now, I assume that there is a very small number of people that actually sit down and read all that stuff. And if they have questions, nobody asks anyway, so they just go ahead and sign it. Most people probably just look at it and say, it's not negotiable anyway, I'm going to go ahead and sign it. It's a little like, what we're talking about here. It doesn't make it, I don't know. You have a choice between protecting those people who consciously choose not to read things and those people that write those things. So that's your choice.
Well, people are saying, well, these are silly things, no one reads it, who cares? The issues are, the real problems here, that we need to have rules of the road when people use these websites. There are real legal issues that come up. This is not just boilerplate. In fact, I tend to read these things, maybe not every one of them. And once I was looking at a site, a small site that posts content up, significant content, and the terms of service said, we have ownership rights to these things. You put it out there, we own it. And I thought, my God, that's crazy. And I left the site and I didn't use it, but there were people unknowingly put up text, video, and all kinds of things, and according to the terms of service, they had rights to it, they could publish it, they could do whatever they wanted to it. And I think most people thought, or had the understanding that that wasn't the case at all, that it was theirs. So
that's absolutely true.
I completely agree with you, and I think that's the case that we keep, the battle with Facebook. Constantly, the battle, they always want your content, and they're always changing the terms of
but
service.
you do need rules of the road. I mean, you can't just say, forget about it.
Absolutely. I completely agree. When I was counsel for a firm, when I was outside counsel for a children's television show, and they had an online web. It went along with the website, with the TV shows, and it had to deal with COPA. And
we should explain for anybody that is a statute that deals with protecting the ability or restricting the ability to take personal information from children under the age of 13 without parents' consent.
And there are some vicious parents out there that read this and they read it to a T, and they will challenge you on it, and they will make sure that they know it. They will write you with questions like, "What do you mean by this? What does this mean? Explain this to me. My child cannot be on this website unless I understand that." But then you have people who are on Facebook, and I think Facebook limited, they dropped it down to 13 now. So 13-year-olds can get on there and put all their information out there because they're no longer part of COPA, because COPA goes up to the age of 13 and under. And this is an issue. I agree, we have to have some kind of rules. It can't just be the wild, wild west. It's like, here's the website, wish for the best. I mean, you have to have terms and conditions that's going to at least guide what's going to be done. And I don't know, I've always, even before going to law school, have read terms and service, especially when my pennies counted. They still count today, but when you have very few of them and they want to charge me a fee, but better yet was when we had a trial, and they would give you 7 days, so you need to read through to make sure if you got charged or not at the end of the trial. You read those things. But again, digressing. We'll go on to the third case. Any other questions?
It did sound like in the Jdate case that you were describing that there was this concept of the terms of service had to be conspicuous, but some of the other problems sounded like they also had to be sort of fundamentally fair. That if you were depriving somebody...
And that addresses...
So it might address that gentleman's point over there, which is, I think he's right. I think the courts, you do need some rules of the road and sort of what else are you going to use other than terms of service that people can see conspicuously. But then I think the courts also probably recognize that it is a contract of adhesion. There is no bargaining that goes on in these arrangements, and they do have to be fundamentally fair, and they wouldn't enforce something that wasn't, because otherwise we'd be left in a situation where I think that would be the default. You just sort of post it conspicuously, knowing that no one would read it, and you can put anything you want in there, and that really just can't be the way of the world.
Right, and that was one of the prongs. They didn't really focus on that on this, but one of the prongs was that it had to be mandatory, and it wasn't just a permissive nature of saying, oh, you can't agree to these are our terms and conditions. It was the fact that every user had to agree to those and click it. It was mandatory. And if you did not use it, then you could not have access to the service. So I agree with you. The courts do look at more than just was it communicated, but was it mandatory to them? And also, in this case, the subject matter, was it ruled and covered underneath the terms and service as well? Moving on to the third case. I don't know if everyone. I don't know Mike. I know I'm going to just give my age away, but does anyone first know who? I don't even know his real name. Ernest Evans. Everyone knows him as Chubby Chapman, and he sued Hewlett-Packard. And the issue here was Hewlett-Packard had an online mobile, well, I don't know if it was mobile, but it was an app store where you can go on, and it was web-based, I'm sorry. It was a web-based store where you can go on and you can buy and download applications. And one of the applications they had on here that they were providing was called the Chubby Checker. And the Chubby Checker estimated the size of a man's genitalia based on the size of his shoes.
It's just
so, yeah.
That's innovation and entrepreneurship.
Yeah. So you put in the size of the shoe and tell you an estimate of what you should be expecting. Chubby Checker decided, and his company sued and said that not only was it an infringement on his trademark, but they willingly and knowingly infringed on his trademark, and that he was suing based on this issue. The courts looked at the case, and this is where we're going to introduce into what's called the CDA, which is the Communication Decency Act. You worked on that, so
yeah,
he's going to
I'll
speak
talk
more
about
in
it
depth of it when he gets up to.
But it's important to make one distinction, and that is that Hewlett-Packard just had an app store.
Right.
They did not actually create the Chubby Checker app.
Right. That's what I was getting ready to go into next. So he alleged that HP was a content provider and not a service provider, and thus was not entitled to the immunity that's under the CDA, Section 230. Now, Section 230 states, no provider or user of an interactive computer service shall be treated as a publisher or a speaker of any information provided by another information content provider. In other words, the safe harbor protects internet service providers from being sued on material published by content providers. In other words, because I have a store similar to HP, Apple, the Google store, they cannot be sued based on the apps that they are putting into their stores. They are not the people who are infringing. They are just making access to such applications to everyone. And in understanding whether there's a safe harbor rule under Section 230, there is a three-pronged test to see if the defendant can satisfy the three-pronged test to gain benefit of the immunity. And the first one is the defendant must be a provider or user of the interactive computer service. 2, the cause of action asserted by a plaintiff must treat the defendant as a publisher or a speaker of the harmful information at issue. And 3, the information must be provided by another information content provider, i.e. the defendant must not be the information content provider of the harmful information. In other words, I am not the one putting out the harmful content. I just have a store and it's being sold within my store. The court found that HP was a provider and it was not the content provider, which created a federal immunity for them under Section 230, precluding the courts from entertaining claims that would place the computer service provider into a content provider role. Now, here's Chevy Checker's argument and why he kept saying the immunity wasn't and that they were a content provider. HP had an approval process. You put in your application, you'd have to get approved. They would not only approve it, but they would approve the design. Then they would also approve it, accept it, upload it, post, market, advertise, and sell the content. So therefore, Chevy Checker says that, hey, look, they are the content provider because they are participating in the design. They are participating in the advertisement and the development in some issues because they would say, look, we don't like this part of your application, or this is not going along with our terms and conditions of our applications, therefore you have to change it. So therefore he says that they were a content provider and endorsing the name of the application, and therefore they should be considered not to have immunity under 203. The court did not agree. And therefore the court says that they were not the ones who developed the apps. They were the ones who named the apps. Therefore, they were not a content provider, and that what they were doing in reference to their approval process, marketing, and uploading it, that all fell under what was called an editorial conduct of a service provider, of what any provider would have to do in accepting applications. And they said further, this court went on to say is that the Section 230 in the immunity, the whole purpose of it is to promote the continued development of the internet and other internet services, and to preserve the vibrant and competitive free market presently existing for the internet and other interactive computer services, unfettered by the federal, state, and regulations. So, this is a case of not the terms and conditions, but whether or not your terms and conditions of accepting content would therefore make you a content provider. And in this case, it was not found that they were a content provider and that they were actually just a provider of services.
And this is one of the most important.
Did Hewlett-Packard leave that out on the website once this case was brought?
You know, it didn't say in the case. I'm not sure. Chevy Checker was not allowed to go after them for infringement, and his case was completely null because they had immunity under it. And if he was smart enough, and I didn't look into it, I apologize, that he probably should have gone after them directly, the app's creators as well.
I can't imagine that the Chevy Checker was making a lot of money for Hewlett-Packard, and the legal fees probably outweigh the sales.
What's interesting about this case is it's the first case that applies this principle. There's this principle that's been around for quite a while relating to if you operate a service that uses user-generated content, should you be responsible for that content? And so this is a case that addresses that issue as it applies to things like defamation, and other types of claims, and that's been applied to services like AOL and Facebook and all kinds of services relating to things like defamation. This is the first case that applied it to an app store, and that's why this case is kind of an important step in e-commerce.
Does this have any bearing on sort of like an online marketplace? Like if the App Store were a marketplace and there's like physical goods, right? Does this safe harbor still apply? Right? Like if you're allowing people to sell counterfeit goods.
So that's an interesting. There is a similar line of cases with eBay that address selling counterfeit goods, and there's a similar there's a similar analysis as to whether the service has liability for selling counterfeit goods. Sorry, yes.
HB was a little smart that would have the users who are posting apps sign an agreement saying it doesn't violate any trademarks, it doesn't violate any other laws, and if it does, you identify all is harmless for any liability, including attorneys.
And so that's a good issue, and the reason why one question that you could have is, well, why are they only suing AOL? Why are they suing HP? Why aren't they suing the person that caused the damage? The seller of the counterfeit goods, the creator of the speech that was defamatory, the trademark infringer. The answer is that they don't have the money. And so, yes, absolutely. And in fact, most of these terms of use do have a provision that says that you're telling me that you own what you're selling, or you're telling me that you're not infringing, and you'll indemnify me if you're wrong. Unfortunately, it doesn't get you anywhere because most people don't have the kind of financial means.
Unfortunately, dealing with a lot of small startup companies, a lot of them will just take the risk, like, okay, you can sue me, but I don't have the money, but okay, yeah, none of this infringes anything. But I've ran in cases like that, and you have to be careful of it. And again, they're not going to go after the person who has the shallow pockets. They're going to go after somebody who has deep pockets.
So I'm just curious, because you mentioned about sort of user-generated content, and if there's a sort of social networking website, people are posting things, you're not responsible. But here it does seem a little bit different in that HP is actually making money off of this particular app, whereas, if I just have a website that's about the New York Yankees, and then somebody starts posting a whole bunch of information saying A-Rod takes steroids and he's a cheater, I mean, I can't really control that. I'm not making any money off of that. It's just people's opinion about a particular subject. But here, I do find it a little odd in that HP was, it was a commercial endeavor on their part, and they were actually reaping the benefits, or whatever benefits Chevy Checker was.
Well, that's a very good point. And so if you're making money, shouldn't you have some sort of responsibility?
Or even after they were put on notice that this was infringing, did they have any?
Well, and that's also a very good point relating to this issue of the statute called the Communications Decency Act. And that is, for the most part, the cases have said that if you are considered not to be a content service, but instead to be considered an information service provider, then you have a virtual bulletproof immunity, even if you get noticed. That's an interesting element of these cases. Excuse me. And what I was going to do, Tanya, if you're done with this case, I was going to give you a little bit of perspective on this, because I'm going to talk about a few cases, including some other cases related to this statute. There are basically two different sets of laws that deal with user-generated content. One deals with copyright infringement, and that statute is the Digital Millennium Copyright Act, which provides a whole array of laws that give a service provider protection for people that are putting up music or movies or some sort of content that is infringing copyright. And there's a separate regime for that. But the gist of that regime, which goes to your question, is a notice regime. And that is, if I'm operating an ISP or an internet service like Facebook, and there's infringing content, there's a law that's in place that basically says that I have protection if I set up a process whereby if you own the song or if you own the rights of the movie, you send me notice
that there's somebody there that's put something on the website, then I have an obligation to take it down. But that's the extent of my responsibility. You can't sue me for money. And the concept is that there could be thousands, hundreds of thousands, millions of songs there, and I can't possibly know whether they're all infringing. But if you tell me, then I have an obligation to take it down. That's copyright. Then for almost everything else, there is this Communications Decency Act. And I was an in-house lawyer when this act was first passed around 1995, and the issue behind this statute, it comes from a case around that same time called Stratton, I guess it was Stratton Oakmont versus Prodigy. Does anybody remember Prodigy? Who remembers Prodigy? I have a little bit of gray. Who else has a little bit of gray? There was a time when there were online services before there was the internet and before there was the World Wide Web. And that included AOL, and it included a service called Prodigy. And you could go online and use the Prodigy service. It was kind of a news service. It was an information service. It did not exist on the World Wide Web. The World Wide Web at the time didn't really exist as a mass medium. And there was on this Prodigy service something called a chat room. Who remembers chat rooms? Where you could go and conduct online discussions. And Prodigy was one of the many services that tried to calm people's fears that they had about tremendous, the amount of interaction with people that they had no idea about, that they didn't know online. And so they said, in their terms of use, that we monitor all of the conversation that go on, that go on in our chat rooms. And apparently in one of these chat rooms relating to investing, somebody came on and said, Stratton Oakmont, which is this brokerage firm, is a shady dealing firm. Well, Stratton Oakmont sued Prodigy for that. Now Prodigy didn't say that they're a shady firm. It was some anonymous person that came on a chat room and said, this is a shady firm. And Stratton Oakmont sued, and Prodigy said, look, you can't hold us responsible. We're not the ones that said it. And the plaintiff said, yes, but you said that you monitor all of the conversations that go on your service. And so you should have responsibility for that. And the court agreed with Stratton Oakmont in that case. Well, I was an in-house lawyer for AT&T at the time. And we were launching at that time a whole bunch of services that were about to go on this new thing called the World Wide Web. And all the lawyers were saying, well, this is terrible because we can't, if we monitor the content, we're going to have liability. We're going to be like publishers. That's what they call it, publishers' liability. We monitor the content, we're going to have liability. So we have to affirmatively not monitor the content. And most other in-house lawyers were at most other services that were in their nascent stages at the time were advising their in-house clients the same thing. Well, there was a problem. And that is, in 1995, what was the most successful business that was being carried on over the internet or online? Pornography. So the government says, there's this case that is basically causing in-house lawyers to advise all their clients, don't monitor services. And yet, there is this growing business, pornography business that's being conducted online. So the government passed this thing called the Communications Decency Act, which was basically designed to address pornography, and it addressed. It was designed to make pornography illegal over the internet. And it also included this provision that said, look, if you are an information service provider, if you are not a content provider, you will have immunity from liability relating to the content. Why is that helpful? Well, it means that even if you monitor the content, you won't be liable for that monitoring. Well, most of the CDA was actually held unconstitutional. So all of the parts of the CDA that said that pornography itself online was illegal, was held unconstitutional as a violation of free speech. But this one provision of the Communications Decency Act held today, and still holds today. And and this is now a body of law that is almost 20 years old. And the way it's developed is that there's been an ever-expanding immunity for information service providers relating to the content, and it addresses things like, most often, defamation. And for the most part, most cases say, you've got immunity. What I'm going to talk about now is one case where they had a different view. The lady on the left is Sarah Jones. Sarah Jones is, or was at the time, a cheerleader for the Cincinnati Bengals. And there's a service called Dirty.com. Now, I tried to see what Dirty.com is by putting Dirty.com in at work, tried to reach the Dirty.com site at work, and I was shut out by firm's filter for rude content. So I can only imagine what Dirty.com actually is. But I can tell you what Dirty.com said. It's basically a site that sort of, I guess, titillates and deals with all kinds of rude and suggestive topics. And it includes user-generated content. Third parties can post on the website. And in this case, somebody, we don't know who, posted about Sarah Jones the following. And there's references to Nick, which is Nick Ritchie, who is kind of the person who runs the site. It says, Nick, here we have Sarah J., captain cheerleader of the playoff-bound Cincy Bengals. Most people, and by the way, this is actually the way it was written, so if there's spelling mistakes, it's not. Most people see Sarah as a gorgeous cheerleader and high school teacher. Yes, she's also a teacher. What most of you don't know is her ex, Nate, cheated on her with over 50 girls in 4 years. In that time, he tested positive for chlamydia, infection, and gonorrhea. So I'm sure Sarah also has both. What's worse is he brags about doing Sarah in the gym, football field, classroom, at the school she teaches at Dixie Heights. And then Nick Ritchie posts after this posting something, very insightful. Why are all high school teachers freaks in the South? Obviously, some pretty rude content, but more than just being rude, it's suggesting certain facts about Sarah Jones. Now, it's also suggesting certain facts about Nate. So one question I have is, well, who's Nate doing this? But we don't know anything about Nate. But it's certainly suggesting some facts about Sarah that are harmful and hurtful. And so Sarah brought a lawsuit against the company Dirty World, which operates this Dirty.com website. And you can imagine that the Dirty World company asserted Section 230C of the Communication Decency Act, saying, I'm an information service provider. I don't create the content. This content, this rude paragraph, came from a third person, and I shouldn't have responsibility, and the CDA says that I don't. And what this case addresses is, well, when can you cross the line from being an information service provider to being a content provider? And basically, what the law says is, if you are involved in whole or in part in the creation of content, then you can be a content provider. Now, what the court said in this case is that effectively by adding that comment about high school teachers, that lovely comment about high school teachers, at the end of that rude paragraph, effectively the owner of the website is participating in the creation of the content. basically, and what the case basically does is it says, well, what was the Communication Decency Act originally there for? Was it there to protect this, or was it there to protect something else? And this is where the case specifically says that the text of the Act indicates that it was intended only to provide protection for site owners who allow posting by third parties without screening them, and those who remove offensive content. So it was intended to give cover to people, to encourage them to screen and to remove offensive content. But if the owners, as in the instant case, invite invidious postings, elaborate on them with comments of their own, and call upon others to respond in kind, the immunity does not apply. So in this case, making one comment at the end of a posting meant that they would have liability, effectively, for that post. So my question to you is, let's take this outside of the internet. Let's put this on television. What if you were a news show and you were covering a press conference and somebody said something that was defamatory and you just happened to make a comment, well, I can understand that person's point of view, or something like that. Does in the context of television, should the person that operates the television station, should the person that operates the television network have liability for what was repeated on a press conference? Yeah.
Well, one other thing, the owner of the site is always in that corporate entity. The person who made the comment was a shareholder or a partial or wholly owner of the corporation. So the owner of the site and the individual are two different people, two different entities.
Yes, I mean the owner. I'm sorry, the owner of the site and the individual.
I'm not saying it right. The owner of the site is a corporate entity most likely, and the person who made the comment is a person.
Yes.
Two different parties.
Absolutely.
So you could make an argument to saying that, well, did the owner of the site add to the content, or was it an individual who's affiliated, and is that enough?
So let's say they're not affiliated, which I think in this case, and in most cases, there's no affiliation between the third party, certainly that makes the statement, and the website that happens to carry it. I mean, one thing that the statute is trying to promote is if you operate a website and you allow third parties to comment, to provide content, I want to incent you to monitor that content and remove offensive content. And so I'm not going to hold you liable for the action of monitoring. But does that mean, does that mean that there's sort of a general immunity? Well, for the most part, yes, unless you are actually thought of as in somehow in part creating the content. Other similar circumstances are cases that have involved, for example, online dating sites where you fill out a questionnaire. There have been cases where plaintiffs have tried to hold the online dating site liable because they say, well, you're the ones that came up with the questionnaire, so you have partly contributed to the content, because if there was no questionnaire, then certain content wouldn't be provided. Courts have basically said that's not the case. For the most part, that just simply having a questionnaire doesn't make you a content provider, including there's a case that involves saying that when there's a site called, I think, ripoff.com, for example, and you're supposed to post complaints that you have about products and services, and there's a questionnaire, and it gives you the opportunity. There's a drop-down box to characterize what you're saying. Is it a ripoff? Is this person a thief? Even in that case, basically, they said that doesn't constitute contributing to the content. But in this case, they said that just making that comment afterwards, and basically, it says, inviting invidious postings. Somehow, this website, because it's kind of a sophomore kind of website, that's inviting invidious comments. And in this case, it's very rare. In this case, they said you're going to be considered a content provider and you're going to be held liable. Sorry, yes?
I think there are also some cases that sort of key on the idea where the publisher or the service provider is sort of adopting the third-party statement. I think it was a roommates.com case.
Yes.
Where they took somebody else's post and they were accused of actually embellishing it and using it in order to achieve some kind of discriminatory effect.
There's a case that dealt with the Fair Housing Act. And that's a specific case where there was a questionnaire and it dealt with roommates. And you had the opportunity to say, let's say you're seeking a questionnaire. There was the opportunity to put in the questionnaire what ethnicity, what race of a roommate you would like. And that was deemed to be a violation of the Fair Housing Act. And because that specific questionnaire dealt with the illegal content, namely the content that violated the Fair Housing Act, the court held that in that case they are directly responsible for the offending content. Now that case was eventually actually overturned later on because it turns out that on appeal the court determined that that actually wasn't a violation of the Fair Housing Act. But in terms of the liability issue for the site provider, that case was one where they were willing to provide for liability for the site provider if in fact there was any liability. Turns out on appeal there was. But yeah, that is another case. I'm going to move along. I'm actually going to skip one case and go to another one because I want to make sure we have enough time to cover these cases. We're moving away from the CDA to the Computer Fraud and Abuse Act. And this is an interesting case that's sort of starting a line of cases relating to Facebook and a company called Power.com. Everyone knows what Facebook is. Power.com is a company that has an application that will help you to aggregate your various social media accounts. And will give you some sort of aggregated dashboard of your various social media accounts. And they operate a website called Power.com. And what you can do with Power.com is, among other things, you can access through Power.com your Facebook page. And that's one way that it integrates Facebook with all the other various social media accounts. Now, Facebook has a terms of use. And in order to have an account on Facebook, and Power.com actually had to open an account on Facebook in order to do what they did. In their terms of use, there is language, and I'll read it, but it's basically language that says that users have to refrain from using automated scripts to collect information from or otherwise interact with Facebook, impersonating any person or entity, or using Facebook for commercial use without express permission. Now, in Power.com's case, what they did was they ran a promotion that basically was designed to get additional customers, where they tried to encourage their current users to introduce them to some of their Facebook friends. And in order to do that, they gave, I'm not quite sure why they felt they needed to, but they gave basically lists of Facebook friends to all of their customers and said, you can refer us to these friends. And if you refer us to these friends, you can win $100. And the way that this Power.com was able to get those Facebook friends was they went on Facebook and they basically scraped that information from the Facebook website. And then they sent emails to whoever said, yes, I'd like to refer you to this person or that person. They sent that person an email from an email that had the suffix facebookmail.com, at facebookmail.com. Well, Facebook complained to Power saying you're going on our site in a manner that is unauthorized because you are doing exactly what terms of use said that you couldn't. You're basically going on and scraping information electronically from our site. And so you should stop. And in addition, Facebook blocked certain IP addresses that they associated with Power.com from accessing the site. They didn't tell Power.com they were doing this. They just did it. There were two actions in this case. One is a can spam claim, which to me is less interesting. Basically said they're liable for can spam because they sent unauthorized email that was, they tried to make people think it came from Facebook. But the more interesting case is the Computer Fraud and Abuse Act. And what they basically said, what the Computer Fraud and Abuse Act basically says is that you cannot gain unauthorized access to a computer, including circumventing technical measures to prevent that access. Well, Power Ventures said, look, we didn't evade any technical measures. We anticipated that Facebook might not like what we're doing, so we actually approached Facebook using multiple IP addresses. And yes, Facebook blocked one or two, but Facebook didn't block all of them. And we just kept on accessing Facebook through the IP addresses that Facebook didn't block. And so we didn't violate the Computer Fraud and Abuse Act, because the Computer Fraud and Abuse Act is designed basically to address hacking. We didn't evade any kind of technical obstacles to get on the website, to get onto Facebook. Well, the court in this case said, look, you anticipated that Facebook would react. You knew that Facebook would try and block your IP addresses. And so all you did was design your service preemptively so that you could get around IP address blocking. Eventually, Facebook might have identified all of the IP addresses that you were using. They hadn't yet. But that doesn't mean that you're not effectively evading those technical measures. So you have a situation where you have a service that is effectively blocking or trying to block, and these people who just were more technically savvy than Facebook at the time and were able to gain access to Facebook to basically just scrape information. The Computer Fraud and Abuse Act prevents that in that set of circumstances. And this is also a growing trend that Aaron's going to speak about. The Computer Fraud and Abuse Act, which is essentially a hacking statute. It's meant to get at hackers, being used to make it criminal. It has criminal penalties. It's a criminal statute that is being used to prevent access to people that they don't want to give access to. And that includes, as Aaron will talk about, it includes websites. It includes public areas of websites, public portions of websites, that you can get the same information by just doing a Google search. And in fact, Google can search without any kind of liability. So that's it for my cases, and I'm going to hand it over to you.
So you're going to go to Craigslist versus 3Taps, which is a very simple case with an amazing result. And at the end, we're going to tell you how to get rich. So this case involves the Computer Fraud and Abuse Act. 3Taps is a company that aggregated data from Craigslist, basically scraped all the data from Craigslist, and also operated a website that reposted all of this information, and would repackage this and sell it to its clients. Two of their clients were also defendants in this case. So Craigslist became aware of 3Taps' activities and sent them a cease and desist letter that said, you are no longer authorized to access and are prohibited from accessing Craigslist's website or services for any reason. Got it. So Craigslist also, this is sort of a secondary point, reconfigured its website to block IP addresses originating from 3Taps. 3Taps predictably spoofed their IP addresses and engaged in sort of a cat and mouse game about blocking and then go around the blocks and take it back. So Craigslist originally sued 3Taps and two other their clients, accusing them of a litany of things: copyright infringement, breach of contract, trademark infringement, and a half dozen other allegations about scraping the data from the website. But for purposes of this discussion, we're going to focus on the CFAA. So, as Marc alluded to, the Computer Fraud and Abuse Act, it's a hacking statute. It's meant to restrict people from accessing computers without authorization or going on areas of computers or websites that they're not authorized to access. And as Marc mentioned, there are civil and criminal penalties that can stem from violation of that. So here's the issue. The question here is, what sort of authorization do you need to access a public website? 3Taps argued that it didn't argue the CFAA because an owner of a publicly accessible website has no power to revoke authorization of a specific user. So basically, by making ads, classified ads on its website publicly available, Craigslist has authorized the world, including 3Taps, to access Craigslist.org. Maybe, right? So Craigslist, through its cease and desist letter, said that we are specifically revoking your access rights, 3Taps. The rest of the world can come on, but you can't. So the question for the court is whether you can do this. Can you revoke access to a specific user? Thoughts? Should you be able to? Should you not? We'll get there.
Right. Because if you're, we're not talking about password-protected areas of a website. Let's say it's LinkedIn. You can go on LinkedIn and you can see certain aspects of somebody's profile. You don't need to link to that person to see that. You don't need to register with LinkedIn. And in fact, if you want to search somebody on Google, right, you can search that person's name and you can find a lot of information on that person that comes from LinkedIn. You can, in fact, link to that LinkedIn page and see that information on LinkedIn itself. So that's a public area of the internet. Does LinkedIn, for example, have the right to say, well, you can do that, but you can't?
Go ahead.
Yeah, it's not public at all. It's still private. It's allowed for use by the public, but that's like allowing someone to walk in and out of a storefront, or at least in alleys to be, right? So you would say you have to act a certain way, you have to wear a shirt to come in. Right? So,
I hate that rule. So I think that's right. And 3Taps also had the other argument is, look, this isn't an unauthorized access case. This is, we're using the information in a way that they don't want us to. And the CFA distinguishes between unauthorized access, which falls under the ambit of the CAA, or unauthorized use, which does not. And so the court was not persuaded by this unauthorized use argument and found that the company's deliberate decision to circumvent the IP address barriers constructed by Craigslist, even though they knew they were banned from Craigslist, violated this access without authorization as defined by the CFAA. The court was not pleased by their arguments. The banned user, being 3Taps here, had only to follow one clear rule: do not access the website. A person of ordinary intelligence would understand Craigslist's actions to be a revocation of authorization to access the website, and thus a fair notice that further access was without authorization. So, 3Taps was essentially just taking the proprietary information from Craigslist, reposting it, and the court said, you can't do that. That's a logical result. But what are the real-world applications of this? And we've alluded to it a little bit. That you can write a letter to a website or a search engine saying, don't search me. You are not authorized to search me. And they do it. And then you sue. And under this case, you'd win. And the court has the judge spent a lot of time thinking about this. And I would encourage you all to read this case and the appeal specific, or the motion specifically on the CFAA, because he understood what the implication of this ruling was. If I want to make a lot of money, I'm going to have a lot of websites. I'm going to send Google an email or some unnamed search engine that says, don't search me, and they'll do it. They're not going to notice, or they can't stop, or they will accidentally search you. And you can sue, because that's unauthorized access. So really interesting kind of result from a very simple case. And these guys were just hijacking content. But the judge was very aware of this and sort of pointed to the legislature and said, I have to do this. This is ridiculous. This is going to have real-world consequences. Hint, hint. Fix it.
Right. I mean, the judge in fact said, I understand the policy issues, I think that this has significant bad policy implications, but the statute says what the statute says. And until Congress changes the statute, my hands are tied. And you make a good point. Well, it's not really public in the sense that it's not public property. But there are examples of services that are quasi-public, like common carriers, where they can't really turn someone down. Where if they're going to make the service available, they have to make the service available to everybody. And the question is whether certain sites ought to have that same status. What if they wanted to shut down their competitors? What if you're Google and you want to say that Bing can't search you, or you're LinkedIn and you want to say Monster.com can't search you? There's real world implications. And like Aaron said, if I don't care about search optimization, why don't I send? And I have a website, and it's a popular website, and I don't really care about search optimization. Why don't I send Google an email saying you can't search me unless you pay me $10 a search?
So we're running short on time, so we're going to move to the next case, which is Avepoint versus Axceler. So, the long story short, Avepoint and Axceler are competitors. Avepoint alleged that Axceler was denigrating Avepoint online, and that specifically Axceler created the impression that Avepoint was a Chinese company rather than an American company, and that customers were generally dissatisfied with their product and moving from Avepoint, the good guys, to Axceler, the bad guys. So, this is a company that's lying about its competitor, so what? Here's where it takes an interesting twist. Enter Mr. Jim Chung. Jim Chung, according to his LinkedIn profile, was a software engineer at Avepoint, located at their Jing'an, China office. Jim started with Avepoint in 2011, and his profile encourages people to contact him for business deals, new ventures, and consulting offers. And his LinkedIn profile is connected to other Avepoint employees. But here's the thing about Jim's LinkedIn profile. Oh, here's Jim hanging out with Avepoint people, saying, "We're partying." Jim was a fiction. Jim was created by Axceler solely for the purpose of spreading this information about Avepoint. And Avepoint alleged that Axceler created LinkedIn profile, publicized it, and sent these tweets. So after partying in Vegas with their Chinese software programmer, they were sued. Avepoint alleged that Axceler's depiction. Here's the other point of this. They also, Axceler, created a fake email address and used that fake email address to obtain a software trial version of Avepoint's software. So this, unlike the other cases, deals with a trademark violation. And specifically, Avepoint said that if you used our trademark, Avepoint, in commerce, you made people think that it was us. You can't do that. So briefly, for a trademark claim, they need to show that they possess the mark, that the defendant's use of the mark occurred in commerce, the defendant used the mark in connection with the sale, offering a sale, or distribution of advertising goods and services, and that it was likely to confuse customers. So the use of mark in commerce was easy. There's plenty of case law that says posted on the internet is an instrument of interstate commerce. We've got that one. The more interesting one is that the defendant, the second prong, the use in connection with the sale, offering for sale, or distribution of advertising goods and services. Now this is a LinkedIn profile, right? So Axceler said, look, this is like a resume. We're not advertising anything here. And it's listing his interests, his gossips, his associations, and that to imply that this is somehow used in commerce, a LinkedIn profile would defy the very organization of LinkedIn. Thoughts on that topic? We're running late, so we'll push through. So the court rejected that this isn't using Avepoint for trademark purposes, the Avepoint mark for trademark purposes. Names are very similar. It's specifically that they're direct competitors, in the software industry, that they masqueraded as an official Avepoint representative on LinkedIn, and they used this fictitious profile to divert business to Axceler and advance their position in the marketplace. The nature of the LinkedIn profile was used for competitive purposes. I think it obviously was. And then there's the breach of contract component to it, which is the terms of use. They also said that they violated the terms of use. How? Terms of use said that users may access, print, or download materials or information from the site solely for personal and non-commercial use. So, again, it's one of those instances where what you say matters. And they specifically prohibited competitors from going on, by having this provision in there, they specifically prohibited their competitors from going on their website, using a fake email address, and downloading their software for competitive commercial purposes. Add that to your terms of service. So the takeaway from this case is that, clearly the court was saying, look, competitors intentionally misrepresent themselves online, diverting customers, so we need to be able to hold them responsible. But brings in the case of what goes on Twitter, what goes on LinkedIn, matters. And so, yes, in a lot of ways, these are kind of fun. You can mess around with them. But, misrepresenting yourself, misrepresenting your customer in a way that's going to lead to confusion, or is likely to lead to confusion, that's an issue. And that happens all the time. So that is where we'll leave us. And on the next episode,
one more time.
Okay. So here we go. Any questions, concerns, comments? Cries of disbelief? So the next one, the last case, is CamUp versus Google. So CamUp was a startup company that invented Google Hangouts, for lack of a better word. They had a very similar idea. They presented at South by Southwest. Google was interested. Remarkably, BN said, will you sign an NDA, Google? And remarkably, Google said, sure. That said, the NDA isn't really the underlying point. Oh, and just to go back to the other case, to bring back to what we were discussing in the beginning, all of these browser wrap cases about, did you agree to the terms of use, require that there's constructive notice, actual or constructive notice of these terms, and something that will demonstrate that you assented to those terms, be it through use or through a click or however you can kind of manifest that assent. So forgetting the NDA claim for a second, BN said, look, at the very least, Google violated our terms of use. Now, here's what's interesting. The court here said, and just to go through the basic contract claims, you're required to form a contract to show manifestation of mutual assent. And so conduct alone isn't necessary to evidence that assent unless the party knows or has reason to know that the conduct would lead to the inference that you have assented. So if it says, stop here and don't click further if you don't agree, and I click, sure, you can draw the inference that I agree. But the court in this case had a very interesting twist on the underlying knowledge of the terms of use, the existence of the terms of use. Go ahead.
What did Google do in this case?
I'm sorry?
What did Google do in this case?
Oh, so Ian created something that looks a lot like Google Hangouts. So they presented their product to Google, and a few months later, Google rolled out Google Hangouts, not involving BN. That was the issue. It was a trade secret misappropriation, all sorts of bad stuff. So in this case, the judge says, look, sure you have your terms of use there, but how do I know Google knew that there were terms of use there? Or what they said, or that they agreed to it? You're not telling me, plaintiff, that they saw it. So if they didn't see it, you can't tell me that they saw it, or that they knew that this existed at all, that this website had any terms of use, then I'm sorry, you're out of luck. So what's amazing is they're just basically saying, Google, sorry, Google didn't know that there was such thing as terms of use. And remarkable result as compared to the other cases we've seen, very similar scenarios. So Avepoint,
the judge there said, as evidence that Axceler, whatever it's called, knew that there were terms of use, said, hey, you're a company, you have terms of use, therefore you must have known that they had one, and look, I looked at yours, they're very similar. So as the law evolves and changes, we're looking at judges becoming more or less comfortable with these adhesion contracts and what it requires to demonstrate assent. Right? So on the one end of the spectrum is just sort of the little link at the bottom of the page that terms of use here. The other extreme is, you've got to click and you've got to scroll down and you've got to agree that you've scrolled down and then you've got to assent, and then there's somewhere in the middle. And in this case, for a lot of reasons, the judge said, look, just having this is not enough. You need to demonstrate something more, which is interesting precedent as applied to Google, but something that I think we should all keep in mind as we prepare and disclose and prominently disclose the existence of these terms and conditions. So, any questions?
This is sort of a general question. We've always talked about users acting in their individual capacity. You have employees using the internet. Let's suppose an employee agrees to terms of service and then violates terms of service. Is the employer liable for the employee's conduct?
That's a good question, and often the answer is yes. And it occurs on so many levels. For example, enterprise software. You can, your lawyer and the client can negotiate an elaborate contract, say with Oracle, for a very, very expensive package of enterprise software. They negotiate specific terms to the extent that Oracle agrees to them. Sometimes they don't, but sometimes they do. And then a new version of an application is disseminated to the enterprise, and some employee opens it up, and there's a click wrap agreement right there. And it says it has terms that are not the negotiated terms that the parties agreed to earlier. There's certainly cases that will suggest that employee that agreed to that click wrap has effectively modified the terms of the contract that you negotiated, and the company will be bound by those terms, which is why it's important when you're negotiating those kinds of enterprise software agreements to put specific language in there that says that an employee that does that is not speaking for the company. An employee that does that does not constitute a written amendment or modification to the contract. So yes, there is that possibility.
And can the employee bind his employer to new terms of service?
The answer is there's a regime of law that addresses when employees can bind their companies, and that exists outside of the online context, but also inside of the online context. And if that standard is met, then yes, the employee can bind the employer.
Anybody else? Thank you very much.
Let's have a big round of applause for really. And I know a lot of lawyers here, I know that brought us all back. Sitting in a law school classroom and going through cases. So, but thank you. That was really a lot of content in a short amount of time. Very useful. So again, anyone who'd like a copy of the PowerPoint, please leave me a business card. I'll make sure you receive it. Or if you'd like to be on the mailing list for future legal track events. I think we still have some refreshments here for anyone who'd like to partake. Otherwise, thank you all for coming, and